Welcome to the deep dive. Imagine this. You're a company director, you're focused on building your business, but then, the market shifts, maybe finances get tight, and suddenly the unthinkable looms the possibility of the business actually failing.
Mm-hmm.
Now, picture that corporate shield, the one you thought, protected you personally. Imagine it starts to feel dangerously thin.
Yeah, that's a scenario that keeps a lot of directors up at night.
And that's really the backdrop here, isn't it? This very real fear that directors in Australia carry the potential for personal liability under those insolvent trading laws. The risk that your personal life could just be devastated by a business downturn, even if, you weren't acting maliciously or anything.
Exactly. And this deep dive is the story of that exact fear coming to life. It played out in this incredibly drawn-out, high-stakes legal battle.
It all kicked off with something pretty common, right? Unpaid invoices.
Yeah, seems simple enough on the surface. But that commercial dispute, it just escalated, turned into this multi-year legal war. You had this tenacious builder, really relentless in chasing the money they believed they were owed for construction work.
And they ended up going after the director personally.
That's right. Once the company itself collapsed, they targeted the director directly, trying to recover the money from him personally.
Wow. And what a journey this case took. I mean, from a completely unexpected loss for the builder in the first court hearing.
Which must have been a shock.
Oh, absolutely. Then through these dramatic reversals, when the case went all the way up to the Court of Appeal, and finally it culminated in this critical final battle, not even about the core debt anymore, really, but about who was going to pay the absolutely enormous legal costs that had piled up over years.
The costs, always a sting in the tail.
So our mission in this deep dive is to take you through every twist and turn of this multi-stage legal saga. We're going to try and unpack the procedural path it followed, really dig into the key legal arguments that were debated at each level.
Yeah, and introduce you to the people involved, the judges, the lawyers, the experts who kind of shaped its course. And maybe most importantly, reveal how this case has actually, clarified and refined Australian legal practice.
Particularly around legal costs and, of course, those enduring responsibilities of company directors.
It's just a really vivid, real-world example of how commercial conflict can get intensely personal and really push the justice system to its absolute limits.
Okay, let's start by getting acquainted with the key players in this legal drama. Think of this as our dramatis personae.
Right. Every good story needs its cast list, and this one's definitely got some interesting characters.
Absolutely. So the driving force behind all this litigation, the ones who were just relentless in pursuing collection, that was Treloar Construction's Piley Ltd. They're a building and project management company. And in this story, they were really the unwavering protagonist, refusing to let this unpaid debt just go.
Their willingness to spend so much time and presumably a lot of money over so many years, it just shows how determined they were to get what they felt was theirs.
Definitely. And standing directly in the path of that determination was Mr. Grant McMillan.
The director.
The director of the company that failed, McMillan Prestige Platy Ltd. So as the director, he was facing that direct, very personal threat of liability under the insolvent trading laws. I mean, the potential for personal bankruptcy hanging over him because his company collapsed.
And the company's financial distress, you mentioned issues with Volkswagen funding. That was part of the backdrop.
Yeah, there were alleged issues around funding they expected from Volkswagen for the actual showroom construction. That whole situation just positioned him squarely in the crosshairs of Treloar's legal action.
Right. And the company itself, McMillan Prestige Platy Ltd., that was the corporate heart of the dispute.
Exactly. That's where the storm really gathered. It operated as a prestige motor vehicle dealership, brands like Bentley, Volkswagen.
Okay.
But its structure was important too. It wasn't just a simple trading company. It was a holding company, financially reliant on the performance of its wholly owned subsidiaries.
So assessing its financial health wasn't straightforward. You had to look at the whole group.
Precisely. And the eventual financial collapse of McMillan Prestige, that was the catalyst. That's what turned this commercial debt problem into a personal claim against Mr. McMillan under the Corporations Act.
And of course, guiding this whole process, making the ultimate decisions, were the judiciary.
Right. At the initial trial of the District Court of New South Wales, we had Her Honor Judge Gibb. She presided over that first hearing, heard all the evidence, and made those initial pivotal findings that, dramatically shaped the first outcome.
But as we know, it didn't stop there.
No, the case went on appeal to the New South Wales Court of Appeal. The bench that heard those appeals and delivered the key judgments, the ones that ultimately turned the whole thing around, included President Beasley, who later served as acting Chief Justice, Justice Gleeson, and acting Justice Emmett.
A senior bench, then. Their collective legal minds really had to grapple with the complex issues here.
Definitely. And then there were other significant figures, particularly the experts whose evidence became central to the factual fights, especially around whether McMillan Prestige was actually insolvent when the debts were incurred.
Yeah, the expert battle, always crucial in these sorts of cases.
So, Mr. Christopher Palmer was the insolvency practitioner brought in by Treloar Constructions. He provided that crucial expert evidence intended to prove insolvency at the trial.
Okay, Treloar's expert.
And working behind the scenes for Mr. McMillan's defense, particularly in that district court stage, was the forensic accounting firm BRI Ferrier.
Right, I remember reading about them. They didn't file their own report, did they?
No, apparently due to timing and cost constraints. They were brought in quite late. But their strategic input was apparently vital. They played a crucial role helping McMillan's legal team pinpoint and target the specific weaknesses in Palmer's report.
So their work was key to McMillan's initial defense strategy.
Seems that way. So those are the main players, the parties, the director, the judges, the experts, the firms whose actions and decisions really drove this saga through the courts for years.
It really is a whole ecosystem, isn't it? So many moving parts in getting a case like this resolved.
Absolutely. Okay, let's rewind back to the beginning. How did this whole relationship start, and what were those first cracks, first signs of trouble that led to all this discord?
Well, the commercial relationship kicked off back in December 2005. Treloar Constructions was hired by McMillan Prestige for a pretty substantial building project.
Right, the new motor vehicle showroom and service facility.
Exactly. A big job for both sides, you'd think.
And the contract for this major project, you mentioned it was surprisingly simple.
Almost unbelievably so. Just a single page, dated 21 December 2005. But hidden in that brevity was this one clause, Clause 1, that became incredibly contentious, a major point of legal argument later on.
Okay, what does it say?
It said, and I'm quoting here, suppliers and contractors organized and paid by Treloar Construction will be charged at cost plus 12.5% management fee.
Paid by Treloar Construction. That little word, paid.
Exactly. That single word became the focus of intense legal scrutiny. On the face of it, maybe it seems clear, but its interpretation was critical. Did it mean Treloar had to literally prove they'd already paid their own suppliers before they could even send an invoice to McMillan Prestige?
Or did it just mean Treloar was the one responsible for paying them and could invoice McMillan Prestige once they'd incurred the cost, whether they'd actually handed over the cash yet or not?
Precisely. That question about the timing and the conditions for invoicing heavily influenced that first court decision.
And adding another layer of complexity was McMillan Prestige's corporate structure, right? The holding company setup.
Yeah, we touched on that. It wasn't just a straightforward trading company, it was a holding company. Its financial survival depended heavily on the cash flow coming up from its subsidiaries, McMillan NSW, the Bentley dealership, and Auto House 5 Dock, the VW one.
So figuring out if McMillan Prestige itself was financially healthy meant looking at the whole picture, the entire group's performance.
Exactly. And the warning signs about the company's finances, they weren't subtle. They were there even before this construction contract was signed.
Do you mean that email from Mr. McMillan?
Yes, the one he sent to Treloar just days before the contract date on 17 December 2005. His own words painted a really stark picture of just how vulnerable they were financially even then.
What did it say again?
He wrote something like, "This is a very, very tough time for our company at the moment, and I am really and genuinely relying on UCPR company's efforts. Our company does not have any resources at present. We are really stretched."
Wow. That's incredibly candid, especially right before signing a major contract. And that email, his own words, that became crucial evidence later on.
Oh, absolutely crucial. It directly undermined any later arguments that he had reasonable grounds to think the company was solvent when it was racking up these debts. It was powerful proof of his awareness of the company's precarious state right from the get-go.
So the contract gets signed, work starts despite these background financial worries, and then the invoices start flowing from Treloar.
Yeah. Between April and September 2006, Treloar sent 11 invoices to McMillan Prestige for the construction work, and they added up. The total was a substantial $418,991.77.
And crucially, they remained unpaid.
Unpaid. And that non-payment was the direct trigger for the legal action that followed.
Things went from bad to worse for the company after that.
They did. The financial problems deepened. In early 2007, receivers were appointed. That was 2 February. And the formal end came later that year, 24 July 2007, when McMillan Prestige was officially wound up by order of the Supreme Court of New South Wales.
And it's worth noting, Treloar Constructions was actually the one who applied for that winding up order.
Yeah, which shows they were already actively trying to recover the debt through formal processes even then.
So the company's gone, wound up, can't pay its debts. Treloar can't chase the company anymore. This is the point where the spotlight swings onto the director, Mr. McMillan, personally. This is where the insolvent trading claim comes in, under Section 588M of the Corporations Act.
Exactly. The Corporations Act has these rules, Sections 588G and 588M, designed to stop directors letting companies incur debts when they know or should know the company can't pay.
Section 588G being the director's duty.
Right, the duty to prevent the company trading while insolvent, basically. If there are reasonable grounds to suspect insolvency, you have a duty to stop incurring debts.
And if you breach that duty,
then Section 588M kicks in. It allows creditors, like Treloar here, who lost money because of that insolvent trading, to sue the director personally to recover their loss.
And Treloar's claim against McMillan focused on those unpaid invoices.
Yes, their initial claim figure was a bit higher, over $600, I think, but the core amount fought over in court was that $418,091.77 from the unpaid construction invoices.
So you've got this ambiguous contract language about payment. You've got documented proof of the company's financial fragility in the director's own words before the contract, plus a complex corporate structure.
It really was, as you said, a perfect storm, just fertile ground for this massive, drawn-out legal fight.
And that fight began in the district court.
Which brings us to Chapter 2, the district court crucible, the first major battle, and a pretty unexpected victory for McMillan and a shock for Treloar.
So proceedings start in the District Court of New South Wales before Her Honor Judge Gibb. Treloar lays out its case.
Yep, squarely based on those insolvent trading provisions. They argued McMillan Prestige incurred that $418,000 debt between April and September 2006, and at those times the company was insolvent or became insolvent because of those debts.
And that Mr. McMillan, the director, failed in his duty to stop this because he knew, or should have known, the company was insolvent.
That's the core argument.
Okay, let's pause and talk about the legal teams. Who was representing each side in this crucial first round?
For Treloar Constructions, you had their solicitors and counsel, and as we mentioned, their case relied very heavily on the expert evidence from Mr. Christopher Palmer, the insolvency practitioner they hired, to prove insolvency.
And for Mr. Brian McMillan.
He was represented by solicitor Somerset Reichmans. His counsel were described in some press reports as being, pretty competent and skillful, but a really key factor on his side was the involvement, even though it was quite late, of that forensic accounting firm, BRI Ferrier.
Right, they came in about 3 weeks before the hearing.
Yeah, something like that. And while they didn't have the time or perhaps the budget to prepare their own formal expert report to directly counter Palmer's,
their input was still vital.
Seems so. Strategically vital. They worked closely with McMillan's legal team to basically pick apart Palmer's report, identifying the weaknesses, the flaws, the questionable assumptions.
So McMillan's defense strategy really zeroed in on undermining Treloar's key evidence on insolvency.
Absolutely. It wasn't just about presenting an alternative view. It was about demolishing the foundation of Treloar's case. And, well, it worked. Remarkably well, in fact.
That's so.
Judge Gibb, in her judgment, ultimately found Mr. Palmer's report to be, and I quote, seriously flawed.
Seriously flawed. That's strong language from a judge.
It is. Her judgment went into detail, criticizing incorrect assumptions he'd made. She found that various of the tables and figures upon which he rested his analysis were either wrong or unreliable.
I remember reading somewhere that Palmer was brought entirely unstuck during cross-examination.
That seems to fit perfectly with the judge's findings and the reported concessions Palmer made under that cross-examination. For instance, he apparently admitted leaving out potential funding from Volkswagen, maybe $700K or $800 that might have been available.
Wow, that's a big omission.
Huge. He also conceded that some of the creditor tables he used weren't reliable, and that he'd wrongly excluded debtor information from the group's trading entities. These weren't minor points. They went right to the core of his insolvency assessment.
So the expert evidence Treloar was counting on just crumbled under scrutiny.
Pretty much. And the direct result was that Judge Gibb concluded she could give very little or no weight to Mr. Palmer's opinion. She found he lacked sufficient information to complete a proper cash flow test.
Which is a massive blow for Treloar. Proving insolvency is essential for their claim, right?
Absolutely essential. And the onus, the burden of proof, is on them, the plaintiff, to prove it. With their main expert evidence discredited, they just couldn't meet that burden. The judge even said she felt she was in a worse position than the expert to make the finding herself based on what was left.
So failure to prove insolvency was one huge reason Treloar lost at trial. But there was another reason too, wasn't there? Related to the contract.
Yes, the contract interpretation. Judge Gibb also based her decision on how she read that crucial Clause 1. Remember, suppliers and contractors organized and paid by Treloar Construction. She interpreted paid to mean Treloar had to prove they had actually paid their suppliers before they could invoice McMillan Prestige. She found Treloar hadn't proven they'd done this.
So she saw it as a condition precedent, something Treloar had to do first.
Exactly, a condition that hadn't been met. So in her view, Treloar wasn't even entitled to issue the invoices yet. This gave her a completely separate, independent reason to dismiss Treloar's claim, quite apart from the whole insolvency question.
And she even commented on McMillan's potential defense under the Corporations Act.
She did, although she didn't strictly need to decide it because she'd already dismissed the case on other grounds. She made some comments, obiter dicta, as lawyers call them. She indicated that if she had needed to rule on it, she would have found that McMillan had successfully made out his defense under Section 580HH.
That's the defense where a director had reasonable grounds to expect the company was solvent.
That's the one. She seemed to think he would have met that test.
So the outcome of this first stage was a clear, comprehensive win for Mr. Brian McMillan, judgment in his favor. And then came the cost orders later on.
Yes, in March 2016, the court ordered Treloar to pay McMillan's legal costs, mostly on the standard or ordinary basis, but for the period after 5 December 2015 on the higher indemnity basis, which means McMillan could recover a greater portion of his actual legal fees.
This first round really underscores how critical expert evidence is in these complex financial cases and how much can turn on the precise wording of a contract.
Absolutely. McMillan's win here seems largely down to a sharp defense strategy focused on dismantling the opponent's key evidence. And BRI Farrier's strategic input, even without their own report, looks like it was really influential in achieving that.
But Treloar Constructions, despite losing completely, despite facing this huge cost order, they weren't done yet. They decided to appeal.
Which leads us into the next phase. Before the main appeal hearing, though, there were some important preliminary battles, procedural skirmishes. We can call this Chapter 3. Appeals and appetizers, the interlocutory joust.
Interlocutory, meaning stuff decided along the way before the final judgment on the main issues.
Exactly. These were applications dealt with by the Court of Appeal, and they were crucial for setting the ground rules for the appeal itself, especially around the financial risks involved for both sides. One key judgment came out in November 2016, Treloar Constructions Flitty Limited v. McMillan 2016, NSWCA 302, delivered by Acting Chief Justice Beasley.
Okay, and who were the lawyers involved at this point? Same team.
Pretty much for this interlocutory stage. For Treloar Constructions, they were the applicant for one motion, and the appellant overall, their solicitors were Diamond Conway, and their counsel was Mr. D. McKay. For Mr. Brian McMillan, the respondent to the appeal, but the applicant for his own motion, his solicitors were still Somerset Reichmans, and his counsel was Mr. J. Shepard. So consistency there for this preliminary round.
Got it. So what were these crucial applications they were fighting over?
Well, Mr. McMillan, having won at trial and been awarded his costs, wanted to protect himself financially during the appeal. He applied for security for his costs of the appeal.
Security for costs, meaning Treloar would have to put money aside to cover his potential costs if they lost the appeal.
Exactly. It's under Section 1335 of the Corporations Act. It lets a court order a company that's suing or appealing to provide security if there's reason to believe the company won't be able to pay the other side's costs if it loses.
And what was McMillan's argument for needing that security from Treloar?
His argument hinged on Treloar's apparent lack of financial substance. His lawyers pointed to evidence suggesting Treloar didn't own any real estate and had very low paid-up share capital, just $100 apparently, according to AGSIC records for its holding company.
Only $100?
Yeah. And crucially, McMillan's solicitors had asked Treloar to provide proof they could actually pay an adverse costs order if they lost the appeal, and Treloar hadn't provided anything. McMillan's team had even warned Treloar they'd make the security application if proof wasn't forthcoming.
And the legal test for getting security under that section isn't super high, is it?
No, it's often described as undemanding. You only need a reason to believe the company might not be able to pay. It's there to protect defendants from being dragged through costly litigation by companies that might just be empty shells.
Okay, so that was McMillan's application. Meanwhile, Treloar had their own financial worry, right? They'd been ordered to pay McMillan's big district court costs bill.
Exactly. So they launched their own application. They asked for a stay, basically a temporary halt on McMillan being able to enforce that district court costs order against them until the appeal was decided.
Why did they want to stay? What was their reasoning?
Treloar argued that Mr. McMillan himself was impecunious, that he didn't have the money. Their concern was that if they paid over this large sum for the district court costs now, and then they won the appeal, meaning the costs order would be overturned, they'd never get that money back from McMillan.
Ah, so a risk of irrecoverable funds.
Precisely. They even mentioned some previous issue they'd had with McMillan's solicitors regarding transcript costs, suggesting they weren't confident about getting money back if the tables turned.
So the Court of Appeal had this balancing act to perform. Protect McMillan, who'd won round one, from potentially unrecoverable appeal costs,
While also not unfairly blocking Treloar from pursuing an appeal that might have merit, especially given Treloar's own concerns about getting their money back if they paid the trial costs now.
Tricky. What did the court decide?
On McMillan's application for security for his appeal costs, the court granted it. Acting Chief Justice Beasley looked at the evidence. No real estate, tiny share capital, Treloar's failure to show they could pay despite being asked, and found it was enough to establish that reason to believe needed under Section 1335.
So Treloar had to provide security.
Yes. They were ordered to provide $75,000 as security for McMillan's appeal costs. And the appeal itself was stayed put on hold until they provided that security. McMillan had asked for a bit more, around $88K, but the court settled on $75,000.
Okay, so McMillan got some protection. And the appeal couldn't even move forward until Treloar put up the $75K.
Yeah.
What about Treloar's application to stay the district court costs order?
The court granted that too. They acknowledged McMillan's conceded lack of funds and also, importantly, noted that Treloar's appeal on the merits was arguable. It wasn't frivolous or hopeless.
But was the stay unconditional?
No, there was a significant condition attached. Treloar had to pay $225,000 into a joint controlled bank account held by the solicitors for both sides.
Wow, $225,000. That's a lot. Why that amount?
It was seen as a reasonable reflection of the likely size of the district court costs Treloar had been ordered to pay. McMillan's lawyers had estimated those costs could be over $200K, and apparently later billed them at over $270K. So while Treloar didn't have to hand the cash directly to McMillan yet, they had to park this very substantial sum, proving they had the funds available if the appeal ultimately failed or the stay was lifted.
This whole interlocutory stage really paints a picture of the strategic maneuvering and financial pressures in big litigation, doesn't it?
Absolutely. McMillan got vital protection for his appeal costs. Treloar got some breathing room on paying the district court costs immediately, but they had to make a huge upfront financial commitment just to keep their appeal alive. Acting Chief Justice Beasley's judgment really shows that pragmatic balancing act courts perform. And this specific case, the 2016 NSWCA 302 decision, is actually cited in legal commentary as a useful precedent on stays and security for costs.
So having navigated those procedural and financial hurdles, the case finally reached the main event, the substantive appeal hearing in the Court of Appeal.
Yes, and this was the major turning point. Chapter 4, the appellate arena reversal of fortune. The appeal was heard by the same bench, President Beasley, Justice Gleeson, and Acting Justice Emmett. And their judgment, delivered on 6 April 2017 NSWCA 72, just completely flipped the script.
Let's check the legal teams again for this critical stage. Any changes from the interlocutory round?
A slight adjustment on Treloar's side. Their solicitors were still Diamond Conway, but for the main appeal, their counsel team was beefed up. They had Mr. T. Alexis S.C. Senior Counsel leading Mr. D.J.A. Mackay, who'd appeared earlier. Adding Senior Counsel, or SILKs as they're sometimes called, is pretty common when cases get to this level.
And for Mr. McMillan?
His team stayed consistent from the interlocutory stage, also led by Senior Counsel. Solicitors were Somerset Rakeman's, and counsel were Mr. E. McGrath, S.C., and Mr. J. Shepard.
So both sides brought out the big guns, the Senior Counsel, for this major showdown.
Definitely. It reflects how high the stakes were. And Treloar Constructions launched a really comprehensive attack, challenging basically every key finding Judge Gibb had made in the district court.
Okay, let's break down their arguments on appeal. First up, they challenged the trial judge's finding on when the debt was actually incurred.
Correct. Treloar argued the debt wasn't incurred back when the contract was signed in December 2005. They said it was incurred piece by piece each time one of those 11 invoices was issued between April and September 2006. They saw the trial judge's view on this as just wrong.
Second, the issue of proving loss or damage under Section 588M.
Treloar's argument here was simple. Their loss was the fact that the valid invoices hadn't been paid. They strongly argued they did not need to prove they had already paid their own suppliers and subcontractors underneath them to show they'd suffered a loss. The debt was owed them, it wasn't paid. That was the loss, plain and simple.
Okay. And the third, absolutely critical point, challenging the finding that the company wasn't insolvent.
Yes, this was huge. Treloar obviously challenged Judge Gibbs' dismissal of their expert, Mr. Palmer. But they also put forward a broader argument. They said, even if Palmer's report had issues, the Court of Appeal should look at all the evidence presented at trial and make its own finding on insolvency.
And they argued the evidence showed insolvency.
They maintained forcefully that McMillan Prestige was insolvent throughout that April to September 2006 period when the invoices were being issued. They relied on the standard cash flow test, could the company pay its debts as and when they fell due. And they pointed to a whole heap of evidence. The overall financial weakness of the McMillan Group structure, Mr. McMillan's own explosive December 2005 email saying they were really stretched with no resources, the clear pattern of late payments, not just to them, but to the tax office too, the company's inability to stick to payment plans, and they argued there was no genuine reliable funding coming from that supposed Volkswagen deal or the informal CBA overdraft.
And finally, they attacked the trial judge's comment, the obiter, finding that McMillan would have had a valid Section 580H defense.
Yeah, they argued that finding was just wrong on the evidence. They said McMillan simply lacked reasonable grounds to expect solvency at the time, especially given his own admissions and the clear signs of financial distress.
So that was Treloar's case on appeal. How did Mr. McMillan try to defend his initial victory?
Well, naturally, he supported the trial judge's key conclusions. He backed her interpretation of the contract, the paid issue, and the related finding that Treloar hadn't proven loss because they hadn't shown they'd paid their suppliers first. He reiterated all the criticisms of Mr. Palmer's expert report that had worked so well at trial.
And he maintained the company wasn't insolvent.
He continued to point to the alleged availability of funding from VW and the CBA overdraft as evidence suggesting solvency, or at least grounds for him to expect solvency. And importantly, his fallback position was, if the Court of Appeal did overturn the main decision, the question of his Section 588H defense shouldn't be decided by the appeal court itself, but should be sent back down to the district court for a full hearing on that specific point.
Okay, so the Court of Appeal had all these arguments before them. They had to reevaluate everything. And their judgment, as you said, delivered a massive reversal. Let's start with that contract interpretation, the paid issue.
This was a huge turnaround. The Court of Appeal flatly rejected Judge Gibbs' interpretation of Clause 1. They looked at it differently, more commercially, considering the context. They decided paid in that clause was about identifying who was responsible for paying the suppliers, Treloar, which was relevant for calculating the cost part of the fee. It was not, they found, a condition precedent. Treloar did not have to pay its suppliers first before invoicing McMillan Prestige.
So that validated Treloar's invoices and confirmed the debt was actually owed. That's pivotal.
Absolutely pivotal. It removed one of the main pillars of the original dismissal.
Okay, what about the crucial issue of insolvency? How did the Court of Appeal approach that, especially given the problems with Treloar's expert at trial?
They took a much more proactive approach. They agreed the cash flow test, paying debts as they fall due, was the right test under Section 95A. But crucially, they didn't just rely on or dismiss Palmer's report. They undertook their own incredibly detailed analysis of McMillan Prestige's financial position during that critical April to September 2006 period.
They did their own number crunching, essentially.
They went through the financial evidence presented at trial with a fine-tooth comb. They looked at the whole picture. The structural weakness of the McMillan Group as a holding company reliant on its subsidiaries, the persistent pattern of late payments to Treloar, to the ATO, the company's documented inability to meet payment plans, and they gave significant weight to Mr. McMillan's own stark admission in that December 2005 email about having no resources.
So his own words really did come back to bite him.
massively. The court also looked hard at those supposed funding sources McMillan relied on. They concluded the letter from Volkswagen wasn't a firm, binding commitment to provide funds, and the informal overdraft with the CBA. They decided it wasn't a genuinely available, reliable resource the company could actually count on to pay its debts as they fell due.
So, based on all that analysis,
Based on their comprehensive review of all the factual evidence, the Court of Appeal concluded that McMillan Prestige was insolvent at each date those invoices were incurred between April and September 2006. They applied established insolvency principles, referencing cases like Lewis v. Doran, and found that Treloar had met its burden of proving insolvency despite the issues with their expert's report at trial.
wow. Okay, so contract interpreted Treloar's way, insolvency found by the Court of Appeal itself. What about proving loss or damage under Section 588M? Did Treloar need to show they'd paid their own suppliers?
The Court of Appeal said no. They overturned the trial judge on this point, too. They held that Treloar did suffer loss simply because the valid invoices, owed by an insolvent company, hadn't been paid. They didn't need to jump through the extra hoop of proving they'd already paid their own suppliers. The loss was simply the amount of those unpaid invoices, $418,991.77.
Okay, that clears that up. And the final piece, the director's defense under Section 588H. The one Judge Gibb thought McMillan would have won.
The Court of Appeal tackled this head-on and decisively rejected it. They found Mr. McMillan simply lacked reasonable grounds for expecting solvency during that period. They emphasized that vague hopes, non-binding letters like the VW one, or relying on an informal, potentially withdrawable overdraft just weren't enough to meet the high bar set by Section 588.
And his own email counted against him here, too.
Hugely. His December 2005 admission and all the other evidence of mounting financial pressure directly contradicted any claim that he had reasonable grounds for optimism. And importantly, the Court of Appeal decided this issue itself, rather than sending it back to the district court as McMillan had wanted. They felt the evidence was clear enough for them to make the call.
So just a complete demolition of the original judgment. What was the final order from the Court of Appeal in this main appeal judgment, the 2017 NSWCA 72-1?
Treloar Construction's appeal was allowed, completely. The district court orders favoring Mr. McMillan were thrown out. The court entered judgment for Treloar Constructions against Mr. Brian McMillan personally for the full $418,991.77 plus interest. And, to add insult to injury for McMillan, he was ordered to pay Treloar's legal costs for both the original district court proceedings and the appeal.
That is just a stunning turnaround, from losing everything at trial and being ordered to pay the other side's costs to winning the full amount plus interest and getting all your costs covered.
It really is dramatic. It highlights the power of appellate review, how a different court, looking at the same evidence perhaps, but applying legal principles differently or taking a more hands-on factual approach, can completely change the outcome.
And it really underscores the significance of contract interpretation and the weight of a director's own admissions.
Absolutely. And it showed the Court of Appeal wasn't afraid to do its own deep dive into the insolvency question based on all the evidence, even if the initial expert report was problematic, and that Section 588H defense, clearly not an easy shield for directors to rely on.
So with the main legal battle over the debt and liability decided, the focus then inevitably shifted to the money, specifically the huge pile of legal costs.
Exactly. Which brings us to the final act, Chapter 5. The price of litigation, the costs conundrum. This wasn't about whether McMillan had to pay Treloar's costs anymore. The appeal court had already decided that. This was about how much specifically should costs be assessed on the standard ordinary basis or the more generous indemnity basis.
And this went back to the same Court of Appeal bench.
Yes, President Beasley, Justice Gleeson, and Acting Justice Emmett heard this costs argument, leading to the judgment Treloar Constructions, Pody Limited v. McMillan, Norton 2, 2017 NSWCA 146, delivered on 22 June 2017.
Legal team still the same.
Yes, consistent through the appeal stages. Diamond Conway with T. Lexus SC and DJ Mackay for Treloar, Somerset Reichmans with Owen McGrath SC and Jay Shepard for McMillan.
So Treloar, having won the appeal, was now trying to maximize how much of their legal bill McMillan would have to cover, pushing for indemnity costs where possible. And they also wanted that $75,000 security deposit back, right?
That's right. They brought 3 separate arguments trying to get indemnity costs for different parts of the long battle.
Okay, let's take them one by one. First, the costs of the original district court trial. What was their argument for getting indemnity costs there?
They pointed to a settlement offer they'd made way back on 7 November 2014. This was more than a year before the trial even started. It was in a letter marked without prejudice and offered to settle the whole thing for $495,000.
Which was less than they eventually won.
Much less. Remember, their claim was estimated at over $1 million plus costs back then. So Treloar argued this was a genuine compromise offer. They said McMillan's failure to accept it, given he ultimately lost badly, should mean he had to pay their trial costs on an indemnity basis from the date that offer expired. They were arguing it was what's called a Calderbank offer.
A Calderbank offer. That's a specific type of settlement offer used to put pressure on costs.
Exactly. It's a common law thing. But did it work for Treloar here?
No, it didn't. Treloar failed on this point. The Court of Appeal reiterated a really critical rule for Calderbank offers if you want to use them to get indemnity costs. The offer must clearly and explicitly state that if it's rejected, the sender intends to rely on that rejection to ask the court for a special costs order, usually indemnity costs.
So the offer itself has to contain the warning, the threat.
Precisely. And Treloar's 2014 letter, although marked without prejudice, crucially lacked that specific warning. It didn't spell out the potential indemnity costs consequence for McMillan if he rejected it.
It was missing the sting, as they say.
Exactly that. The court said that essential requirement was missing. Even though the offer might have been a genuine compromise, the failure to include the explicit warning about costs consequences was fatal to using it for an indemnity costs order. They mentioned other cases like Whitney v. Dream Developments on this point. So Treloar got their district court costs, but only on the ordinary basis. A potentially expensive omission in that 2014 letter.
Okay, so the Calderbank attempt failed. What was the second try for indemnity costs?
Treloar sought indemnity costs for the legal fees they incurred dealing with McMillan's own process to get his district court costs assessed. Remember, after McMillan won at trial, he started the formal process to get his costs quantified. Treloar had warned his lawyers at the time, if you proceed with this assessment and we later win the appeal, we're going to ask for indemnity costs for having to deal with this assessment process.
Makes sense. Did the court agree?
No. Treloar failed again here, but for a different reason. Jurisdiction. The Court of Appeal found it simply lacked the power or authority to make costs orders about that separate costs assessment process. Why not? It was related to the same case.
Because costs assessment in New South Wales is largely governed by a different law, the Legal Profession Uniform Law, LPUL, not the Civil Procedure Act that governs the main court proceedings. The assessment itself is handled by specialist costs assessors or maybe different tribunals. It wasn't within the Court of Appeal's remit while hearing the main appeal. They couldn't just tack on costs orders from that separate process. It clarified those jurisdictional lines.
Okay, so 0 for 2 on indemnity costs so far. What about the third attempt? This related to the cost of the appeal itself. Yes, and this is where Treloar finally succeeded. During the appeal on 18 August 2016, Treloar's lawyers sent another, more formal settlement offer. This one was explicitly marked without prejudice except as to costs, and crucially stated it was made in accordance with Rule 20.26 of the Uniform Civil Procedure Rules 2005 NSW, the UCPR.
A UCPR offer of compromise. That sounds different, more official than a Calderbank.
It is. It's a formal mechanism provided by the court rules themselves. This offer proposed settling the appeal by letting judgment be entered for Treloar for $190,000. It was left open for 35 days following the rules. McMillan didn't accept it.
And Treloar eventually won much more than $190,000 in the appeal.
Way more. They got the full $418,990,000 in the appeal.
Way more. They got the full $418,990,000 offer.
And what did the court say about this UCPR offer?
The court found this 18 August 2016 letter did meet all the strict formal requirements of a valid UCPR offer of compromise under Rule 20.26. And because Treloar made a valid offer, it wasn't accepted, and they got a better result. Rule 42.142 of the UCPR kicked in.
What does that rule say? It's pretty prescriptive. It says, in this situation, plaintiff makes offer, defendant rejects, plaintiff gets better judgment. The plaintiff, Treloar, is entitled to ordinary costs up to the date the offer was made and indemnity costs from that date onwards, unless the court orders otherwise.
And did the court order otherwise?
No. The court found no discretionary reason to order otherwise. So because Treloar used the formal court rules process correctly, they got their appeal costs awarded on that split basis. Ordinary costs up until 18 August 2016, and the higher indemnity costs for everything after that point. That really highlights the difference, doesn't it? The Calderbank offer failed because it missed the magic words, but the formal UCPR offer, done by the book, delivered the indemnity cost outcome almost automatically.
Exactly. It shows the strategic advantage and relative certainty of using the formal UCPR offers of compromise. If you follow the rules precisely, you have a much stronger claim to indemnity costs with less room for the court to refuse compared to the common law Calderbank approach where that explicit sting is everything.
Any other final orders from this costs judgment? Yes, two things. The $75,000 security for costs that Treloar had paid into court way back was ordered to be released back to them. And the prejudgment interest calculated on the debt, a hefty $321,974.45, was formally added to the judgment sum, making the total principal and interest owed by Mr. McMillan personally well over $740,000. Even before you factor in the massive legal costs bill he now also had to pay.
Wow. This final stage, Treloar, No. 2, just powerfully illustrates the huge financial impact of costs orders and how critical the mechanics of making settlement offers are. Missing the sting in the Calderbank cost Treloar dearly on the trial costs, but getting the UCPR offer right secured them indemnity costs for a big chunk of the expensive appeal process.
It's a potent lesson for anyone involved in litigation. Winning on the merits is step one, but managing the financial fallout through procedural tools like settlement offers is just as crucial. The difference between ordinary and indemnity costs over years of fighting can be absolutely enormous.
Hundreds of thousands easily, if not more in some cases.
So after this incredibly long journey through the courts, what's the lasting legacy? What echoes does the Treloar v. McMillan case leave behind? Chapter 6. Echoes in the Halls of Justice.
Well, the judgments, especially that Second Court of Appeal decision on costs, 2017 NSWCA 146, have definitely left their mark on legal practice, particularly in New South Wales where the case was decided.
Let's start with the impact on settlement offers and costs. How has it changed things?
It's become a key case, a reference point. For Calderbank offers, Treloar No. 2 just hammers home yet again the absolute need for that explicit statement, the clear intention to rely on rejection to seek indemnity costs. The sting has to be there, unmistakable.
So legal practitioners really need to be precise in their drafting.
Absolutely. Legal commentary from firms often points to this case as a stark warning. Just marking a letter without prejudice isn't enough if you want to use it later to argue for indemnity costs. That specific warning language is essential.
And for the UCPR offers?
The case really confirms their strategic value and the certainty they offer compared to Calderbank's. If you follow the UCPR rules correctly, like Rule 20.26, and get a result that triggers Rule 42.14, your entitlement to indemnity costs is much stronger, much more defined by the rule itself. There's less wiggle room for judicial discretion to deny it. So it encourages lawyers to use this formal court mechanism.
The case also clarified those jurisdictional lines regarding costs assessment.
Yes, the court's refusal to award costs for that separate assessment process really highlights that different legal activities, even if related to the same underlying dispute, might be governed by different laws like the Civil Procedure Act for the court case itself versus the legal profession uniform law for assessing the lawyer's bills. And different bodies handle them. Practitioners have to be careful about which court or tribunal has the power to award costs for which specific part of the process.
Okay, moving beyond the cost specifics, what about the broader lessons from the whole saga, starting with directors' duties and insolvent trading?
Well, the fact that Treloar ultimately succeeded in their claim against Mr. McMillan personally under Sections 588G and 588M is just a very real practical reminder of the significant personal financial risk directors face if they let a company trade while insolvent. It shows these Corporations Act provisions have real teeth.
It makes the theoretical risk very concrete.
Exactly. It illustrates how the corporate shield isn't impenetrable, and directors can be held personally liable for company debts if they breach that duty. Academic papers and judicial commentary sometimes reference this case for exactly that point.
And what about the challenge of proving insolvency itself?
Treloar, too, the main appeal judgment, it's interesting here. While Treloar's experts stumbled badly at trial, which was nearly fatal, the Court of Appeal showed it was willing to roll up its sleeves and do its own detailed, holistic analysis of the company's finances based on all the evidence.
So the expert isn't necessarily the be-all and end-all.
Not always, it seems. The court looked at everything: the group structure, the late payments, the director's own admissions, that email, the lack of real funding. They relied on established insolvency indicators, like those discussed in cases like Lewis v. Duran. It shows compelling circumstantial evidence can win the day. However, it also shows the huge risk you run if your main expert evidence collapses at trial. You might get lucky on appeal, but it's a massive gamble.
And going right back to the very start, that simple one-page contract.
It's just such a powerful, maybe humbling lesson about contract interpretation and the importance of clear drafting. The entire outcome, at least initially, hinged on how one judge interpreted a single word, paid, in a short contract clause. The fact that the district court and the court of appeal read it completely differently shows how ambiguity can lead to massive legal fights and uncertainty. It just screams, get your contracts drafted clearly.
Looking back at the timeline, too, debts from 2006, final court resolution in mid-2017. It's a sobering reminder of the sheer cost of litigation, not just in money.
Oh, absolutely. The time involved over a decade from when the debt arose to the final judgment. The financial resources Treloar's trial costs alone were estimated over 150 Ks before the appeals, so the total bill for both sides over the entire saga must have been astronomical, easily high, 6 figures, maybe 7. And the emotional energy, the stress, pursuing a claim like this, especially after losing the first round, it takes an immense toll. It's a real cautionary tale about the price of justice through protracted court battles.
And finally, the whole case just perfectly illustrates how substantive law and procedural law are intertwined, doesn't it?
Completely symbiotic. You have to win on the substance, prove the debt, prove insolvency, defeat the defenses. That's essential. But the practical outcome, what you actually recover or end up paying, is profoundly shaped by how you navigate the procedures.
Like how settlement offers are made, or whether you apply for security for costs.
Exactly. Those things aren't just administrative hoops, they're strategic weapons. Treloar, the costs judgment, showed that winning the main appeal was necessary, but the details of how Treloar made its settlement offers dictated the financial scale of that victory. Getting the UCPR offer right made a huge difference to their bottom line. Procedure isn't separate from the outcome, it shapes it.
And there you have it, our deep dive into the twisting saga of Treloar v. McMillan, a really long and complex legal fight that started, like so many, with unpaid invoices.
But it escalated into this intense personal claim against a company director, featuring that unexpected initial defeat, dramatic reversals on appeal driven by different legal interpretations, and deep factual dives.
And culminating in that critical, precedent-setting battle over who pays the enormous legal costs.
It's just a case packed with lessons, isn't it? For directors, about the real personal stakes of insolvent trading. For businesses, about the absolute need for contract clarity. For lawyers, about the rigorous standards for proving insolvency relying on defenses. And, crucially, the strategic importance of understanding and correctly using settlement offers to manage the brutal costs of litigation.
It really shows that in these complex commercial disputes, victory isn't just about being right on the law. It's often just as much about skillfully navigating that procedural minefield and carefully managing the intense financial pressures.
Which leaves us with a final thought for you, the listener, to perhaps mull over. How might understanding these procedural details, like the difference between a Calderbank and a UCPR offer, or the impact of a security for costs application, actually change how you might approach settling a dispute, or even just how you assess the real risks of heading to court?
Or maybe thinking about Mr. McMillan's experience and how the Court of Appeal dismantled his Section 588H defense. If you were a director facing tough financial times, what steps could you actually take to ensure you do have reasonable grounds to expect solvency? What does reasonable grounds really look like in practice, given how high the court set that bar?
Definitely something to think about.
That's all for this deep dive. We hope you found this journey through the halls of justice as dramatic and insightful as we did.